tonight. This is a pretty fun class for me. But I really am interested in law and so forth. And so researching law and politics in the Joseon dynasty was really telling. I'm working, my paper, my project that I'm doing for later is on historiographical discontinuities, or like various dilemmas you get reading colonial era history and post-colonial era history. And one way that this is manifest really well in the way that we have these differing teachings, historical teachings, is in the issue of law and jurisprudence in the Joseon dynasty. So first and foremost, what I want to talk about is how jurisprudence in the Joseon dynasty was primarily Confucian. They didn't have Western notions of law, whether it be case law, statutory law, or branches of government determining law and so forth. It was a Confucian notion. However, we have a lot of historians in Korea today, particularly contemporary ones, that try to assert that there was customary law in Joseon Korea before the colonization of Korea by Japan. This is false, and we're going to talk about why they talk about that, why they feel like they need to say there was some sort of customary law. And we're going to do it by talking about historical progression. Starting, actually, we're going to leave Korea, go to Europe for a second, talk about Western notions of customary law, and then we're going to talk about how those notions had influence in Japan. And when Japan eventually annexed and colonized Korea, they began to codify a law that was, in essence, customary. But since the Korean peninsula has established its own autonomy and Japan has left the area, there have been various historiographical attempts to redefine this legal history. To say, basically, no, we did have customary law before Japan came. We'll prove it to you, but in actuality, I'm going to prove you the opposite, that they didn't. The actual legal practice in Joseon Korea was distinctly Confucian. In other words, we're going to talk about what the laws were, what historiography has tried to say what the laws were, and what this teaches us about the relationship between nationalism and history. So like I said, we're going to leave Korea for just a minute and go to the West. We're going to talk about what customary law is. I think that's important to understand. Where most laws, we understand it in the United States, is established from the top down, meaning you have whatever branch of government establishes in the legislation. They're a body of people that is only so big, and yet somehow it applies to the general populace. So it's top down. Western notion of customary law, you could say, is law from the bottom up, where customs or traditions that we have become to dictate our relationships with one another. And then when you take an issue to a court of law like Judge Judy or something, and she makes a decision on who is right and who is wrong, it's based on these customs. And now that Judge Judy has said, okay, well, you're right, you're wrong, we've made this custom a law. It is now something that's legally binding. And that's what this quote here says. It says it doesn't have to necessarily be written, but it facilitates interaction with people through reciprocally acceptable, well-established adjudication arrangements accompanied by effective legal sanctions. So I don't know I doubt you know who this guy is. You can never tell by just an old picture. But this man's Fernando Mendes Pinto. He was a Spanish explorer that was one of the initial explorers from Europe of the Japanese islands. And with his work, his naval work, we have established a Euro-Japanese relationship for the first time. And this is when Western notions began to infiltrate the Japanese psyche. Very, very important article in regards to this topic. It says, in East Asia, the first attempts to codify customary law took place during 1870 and 1880 in Japan, and 1900 and 1930 in China, when Japanese and Chinese officials, respectively, attempted the redaction of a modern civil code with a view towards creating a, quote, modern state. And this is the deal. They saw a world that was becoming increasingly global towards the end of the Joseon dynasty, and they wanted to be modern, which I guess to them meant adapting. Now, why am I talking about Japan and Europe? Well, what happened in 1876, 1905, 1910? These are dates that represent a historical progression towards the annexation and colonization of Korea by Japan. So all of a sudden you have Japan and Korea doing this, trying to make a modern state, which in other words is a Western state. I think it's kind of ironic that they just assumed the Western state was the modern one. But it seems to be there's no way around that now. So anyway, the Japanese, what they did was they went around in Korea the same way Hammurabi did in Mesopotamia and every major law code has ever done. They went around to all the villages and towns and cities and basically started writing down all the customs that they could find, all these customs, and they integrated it into a codified law. But the problem is that you have a lot of Korean historians who say now, well, look, they codified a law, and they made a law, and they made it official, sure, and they wrote it down, sure, but we had an oral law that was customary. I mean, where did they get it? They got customs, right? They got our customs. But there's a difference legally between the word custom and the word customs. A custom, or customs, plural, is traditions. But custom is customary law. For example, in our first presentation today, she talked about how a custom was that a woman's role was domestic. That's a tradition. That's a custom. But custom was that women didn't have inheritance rights because of this patrilineal adoption thing that happened. That was much more legal. And that's the difference between custom and customs. And so what's going on now is you have a lot of nationalist Korean historians who are trying to say that customary law existed before the Japanese colonial period. And that's false. What existed before was customs and traditions. And these customs and traditions were born of Confucianism. Now, this picture here is one of the most significant pictures in the legal world. This is a picture of Saint King Louis, one of the famous kings of France. He has on a blue robe, standing on a cape of red, man kneeling at his feet, the oak tree, the scepter, the tall buildings in the background. These are all rather cliche symbols, actually, of justice. He's doting out justice. He is a symbol of adjudication. And what's going on in these societies, and in today's American society as well, law is determined by case-by-case disputes. So someone comes up, for example, King Solomon. Remember the story about the two women who come claiming parentage over a child? And he says, well, why don't we just cut the baby in half and give them to both of you? And then the mother says, no, don't do it, let her have it. And he realizes that the woman who said this is the actual mother. You recall this story, I'm assuming? That is a case of a king determining law on a case-by-case basis. And these cases build upon each other to create what we call common law, making precedent. That is not how this guy decided things should be done. Who's this? This Confucius. For Confucius, laws were different. It wasn't a case-by-case thing. It was an overreaching moral principle that was designed to create harmony. From the same article that I quoted earlier, I want to read every word of this, and I apologize. We'll probably go 2 minutes over, so if you need to leave, don't be offended. But she says here, one observes that the pre-modern Korean legal system was grounded in universally valid ethical principles. The main goal of adjudication was to straighten moral attitudes, and the merit of the individual party's claims was regarded as less important than the need to propagate virtuous conduct and punish the undisciplined. Private disputes and social ills were to be remedied by exhortation and persuasion rather than legalistic argumentation. Disputes among family members were viewed with particular aversion as they disrupted social harmony and hierarchy, and wrangling between the legitimate and illegitimate branches of the family was a priori decided in the legitimate branch's favor. So what we see is they were attempting not to say, you're right, you're wrong, let's figure out what's most fair and move on and write it all down. They were more concerned with, you're right, you're wrong, you need to be punished, and we need to do this as quickly as possible so that we can contribute to this harmony. So some ideas, some things we know about the Confucian law of the day, or this Confucian option, is that it was based on principles of quick litigation. When a Confucian-era court or ruler of whatever province was given a certain case, they decided them quickly. This was because the longer the case, the more disruptive it was. And Confucianism is all about harmony. Disruption is the opposite of harmony. Another thing is that there is a singular legal system. It's not stratified. You don't have differing branches or appellate courts or anything like this that are attempting to find out the most fair decision. You have a rule and you follow it. And the rule is Confucianism and its customs that come from Confucianism. It is not custom in the Western sense. What was eventually called customary law, customary land rights, customary political structure, and so on, were in fact all created by colonial codification. These weren't laws dictated by legislators and culturally legitimized by common law precedent. They were customs determined by an ethical code, and in this case the code was Confucianism. So it's important to recognize the Japanese instituted a customary law system, not the Koreans. So why then do contemporary Korean historians insist that they already had a customary law system in Joseon, Korea? And this is the issue that we come across in a lot of Korean historiography. And I've written a few examples here. For example, the Tongun myth. I mean, they abandoned it by the colonial period, but they came back to it in the post-colonial period. It's an attempt to somehow nationalize and legitimize this Korean state. Now that it's, because Korea, if you think about it, it's still kind of a baby. And if you think about it, and how old is Korea, that question from the first exam. If you pick the youngest option, Korea is very young. They're still trying to find an identity. You see examples in art, post-colonial art versus colonial art, even in textbooks. There was a great study that was made by three Korean professors of education, and they compared post-colonial and colonial textbooks, and they talked all about all these differences between the way that Korean history is interpreted after Japan leaves and while Japan was there. And this law thing is just another example of this. And so that's my presentation. Are there any questions about anything? I spoke pretty quick. Go ahead.
Not necessarily about your presentation, but this is your. I actually asked this question. But it's your first reading in class.
Yes.
What did you think? Like, did you think it was
good.
interesting? Like,
Yeah.
What is your specialty?
Well, my specialty is American politics, history of American politics.
Yeah.
And so, I often have I'm not terribly concerned with names of dynasties and stuff.
Yeah.
But I'm always interested in political structures and what you can learn from them. And I think that this is, for example, this topic in particular really interests me. Anyway, thank you very much.
Thank you.